first of all, we have to repeal a lot of stuff. And some of that is easier, right? So repealing laws, the Climate Change Act, the Equality Act, the Human Rights Act, all of these, they're always referred to as Blair era, but actually most of them are Brown era. Blair was too savvy to do things that blatant in most cases, other than the Human Rights Act. But then we've got to undo his judicial reforms. I think we have to undo the Supreme Court. As soon as you create a Supreme Court, it starts getting ideas with a name like that. And starts doing things that would have been unthinkable as recently as the 90s. You then need, and I think this is the most important, you need to tackle the openings for judicial review domestically. I was very struck by a line in the judgment that overturned the Rwanda scheme. Where, I mean, first of all, extraordinary that happened, right? That Parliament expressly passes a law saying we declare the following policy and the court strike it down. But the way in which the Court of Appeal eventually struck it down, there was a line in there where they said, contrary to the principles of customary international law. Now, I don't think there's such a thing as customary international law, right? The international law exists in the form of treaties and, protection of diplomats and Vienna Conventions and all that. But the idea that there's some kind of caseload that you can draw on as if it were domestic precedent is sheer invention. And that was the judge's way of saying, even if you pull out of the ECHR, and even if you pull out of the 1952 UN Convention on Refugees, we're still not going to let you deport people because we'll claim that it's contrary to the principles of customary international law. Now, in that situation, you really do have an attempted coup. Wonderful observation that I think Michael Howard once made, that a court with a mission is a menace, but a Supreme Court with a mission is a tyranny. And we're very, very close to that point.